Are you anxious and confused about whether to use a life estate deed or a trust for your property? Well, it's time to put an end to those sleepless nights and get clear answers. So hang tight, the answer might surprise you. I'm estate planning attorney Mike Smith with Smith Barid LLC, and I'm one half of the estate planning guys. Now, the first thing we need to do is to define what we mean by the terms life, estate, deed, and trust in this case. And we're going to talk about a special type of trust. So, a life estate deed is an interest in property during your lifetime that passes to another individual when you die. So in property law, when we own all of the rights to a property, it's called a fee simple estate. And we can give that fee simple estate to someone else by signing a deed. We can give them that property, or we can give them a portion of the rights to the property. And a life estate deed is a way to give someone else a portion of the rights to the property. So with a life estate deed, if I sign a life estate deed to my children, then during my lifetime, I will have the right to what we call enjoyment of the property. So I will be able to live there. I can rent the property out. I can use it as I see fit. The only thing I can't do is sell the property without the permission of the person that holds the what we call remainder interest. So my children in this case. And when I die, if my children hold the remainder interest under this life estate deed, then the property will pass to them automatically without having to go through probate. So that's a great way to avoid probate if you want to transfer property to your kids when you die. You can use a life estate deed to accomplish that. So if you're interested in learning more about how we help families protect their legacies from probate, predators, and government intrusions, I wrote a free book titled The Ultimate Gift that lays it all out. If you'd like to pick up your free copy of The Ultimate Gift, simply click the link below, give us your address and a credit card for shipping and handling fees, and we'll ship it out to you free of charge. Read The Ultimate Gift so you can learn how to protect your family. Now, the other way that we could handle our property is with a trust. And I'm going to talk specifically about a Medicaid asset protection trust in this case. So a Medicaid asset protection trust is a trust that's designed to protect assets so that if you need to go into a nursing home, those assets won't count as part of your estate and therefore won't count in terms of your eligibility for Medicaid. So if we put assets into a Medicaid asset protection trust, because of the way the trust is structured, they don't count as our assets. When we put the assets into that irrevocable Medicaid asset protection trust, we're effectively kind of giving away the assets. We can remain as a beneficiary, we can remain as an income beneficiary, but we're effectively giving control of those assets over to the trustees of the trust, which if you think in a normal family situation, you might anticipate needing nursing home care at some point down the road and therefore set up a Medicaid asset protection trust. You might name your children as the trustees of the trust. So you would be giving your children control over the assets in the trust, and then you might transfer your real estate, your home, into that trust. And what that's going to do is, as I said, number one, if you need nursing home care and more than 5 years have passed, the assets in that Medicaid Asset Protection Trust won't count for you for Medicaid eligibility purposes. So for Medicaid qualification in the state of Georgia, you can have no more than $2,000 in assets. And while your home is an exempt asset for Medicaid purposes, if you own a home and you've used Medicaid benefits, when you die, Medicaid will come back to your family and say, hey, we paid $250,000 for your dad's care in the nursing home, and now you're gonna have to pay us back from his estate. So what can effectively happen is that even though your home is an exempt asset for Medicaid purposes, when you die, your home will go to the state to reimburse the state for the expense of taking care of you. If you, however, have put your home into a Medicaid Asset Protection Trust, then the value of your home is in that trust. And as long as 5 years have passed before you go into the nursing home, that transfer does not count against you. They don't even need to know about that transfer if it's been more than 5 years. And when you die, they won't be able to come back against the property that's left in that trust. And so that's a way that you can get your home to your children without there being a Medicaid lien when you die. It's a great way to plan for Medicaid, and it works for houses and other types of assets that you might have as well. Now, one of the things that is sort of a drawback to a life estate deed. Remember, it avoids probate. The Medicaid Asset Protection Trust also avoids probate. But one of the drawbacks to a life estate deed is that, remember, we talked about if you own the entire property, it's called a fee simple estate, sort of the whole pie. And if you sign a life estate deed and you give your children a remainder interest in the property via that life estate deed, then you are giving a piece of the pie away. If you own a life estate deed like that, when you apply for Medicaid, Medicaid is going to assign a value to the life estate. Remember, you don't have the whole pie anymore. You've given away a piece of it, but they will assign a value to it that's based on your age and life expectancy and what the value of the property is, what the value of the whole pie is. With a Medicaid Asset Protection Trust, we don't have that issue because you've transferred all of your interest in that property into the trust, and therefore it doesn't count. There's not even a portion of it that counts in the tally of your assets for Medicaid eligibility purposes. So it does have an advantage. A Medicaid Asset Protection Trust does have an advantage in that that property is not going to count for Medicaid purposes at all. Whereas if you have a life estate deed, while it does help you to avoid probate, that life estate that you retain in the property is going to count for Medicaid purposes and may make you ineligible for Medicaid. So it's important that when you consider, like, how should I handle my property in terms of passing that on to my kids? Obviously there's a lot of different ways you could do that. You could just have a will and you could leave it to them in your will. You could have a trust, different types of trust. In this case, we're talking about a Medicaid Asset Protection Trust, but you could use a revocable trust if you wanted to. That won't help you with Medicaid eligibility. But it's important to know what the differences are in the way that you can transfer this property to your kids. And we find that most of the time, the best way to do that is to work with a qualified estate planning attorney who can help you with these issues. Now, in our firm, we handle estate planning matters, wills and trusts and that sort of thing. And we also help folks with elder law issues. So that's why we understand what the issues are with respect to Medicaid qualification, other benefit programs that might be available for seniors to help pay for long-term care. So that's an important thing about working with Smith Barid, is that we know a lot about general estate planning as well as planning for long-term care. So if you need our help, feel free to click the link below. If you have questions about anything, you can leave comments. The link below will take you to a scheduling page and you can schedule a free discovery call with somebody on our team to help us determine if we'll be able to help you. Again, I'm Mike Smith with Smith Barid LLC, and I'm one half of the estate planning guys. We look forward to seeing you in our next video.